Hello friends, I am Rahul Deshmukh, working as an assistant professor in Sri Omkarnath Malpani Law College, Sangamaner. Today's topic is anti-ragging laws in India. Ragging is a Western concept and we can call it as a social interaction between the seniors and juniors in college or schools. But this kind of interaction when become inhuman, unhealthy, then it's become a serious things in the colleges or in the schools. In this topic, today we are going to discuss various anti-ragging laws in India. In India, anti-ragging laws and their framework, their punishment and preventive measures are provided. In India, if we think or discuss on the concept of ragging, the first thing is that what is meant by ragging. So, ragging means any abuse, harassment or intimidation of students. In India, ragging recognized as a criminal offence and ragging is governed by the state laws. Every state having its own anti-ragging laws. In Maharashtra also, Maharashtra state having its own anti-ragging laws. Supreme Court in its judgment Vishwa Jagriti Mission versus Union of India 2001, the public interest litigation was filed by the Vishwa Jagriti Mission. This is the first major case recognizing ragging as serious issue affecting student rights under Article 21 of the Constitution of India, that is right to life and dignity. So, this is the first case. Then the another important judgment of Supreme Court in the case of University of Kerala versus Council of Principals of Colleges in 2009. In this case also, the Supreme Court of India directed the UGC, that is University Grant Commission, to frame regulation and also stress on the formation of anti-ragging committees in schools and colleges. Then after the Raghavan committee report is also an important document in the formation of these anti-ragging laws. Raghavan committee was appointed by the Supreme Court and the committee also submitted its report to the government or to the court also. On the recommendations of this committee or whatever the study which was done by this committee, anti-ragging laws are framed in India. Specifically, UGC regulations on curbing ragging 2009 was brought into force in 2009, which is binding on all the institutions, on all the colleges, schools, institutions, universities. Then the second important legislation, that is Maharashtra Prohibition of Ragging Act 1999. This act specifically enacted by the Maharashtra government for prohibition of ragging. The third important legislation, that is Bhartiya Nyaya Sanhita. Under this Bhartiya Nyaya Sanhita, various provisions are also applicable for the prevention of ragging in school colleges. The first document we are going to discuss on that is UGC regulation on ragging on 2009, UGC regulation on curbing ragging 2009, issue under section 26 clause 1 subclause G of the University Grant Commission Act 1956. This regulation based on the directions of the Supreme Court of India, as I already mentioned the first case, that is Vishwa Jagriti Mission versus Union of India 2001. The regulation is based on specifically on this case, and the another judgment of Supreme Court, University of Kerala versus Council of Principal 2009. The UGC regulations are based on these two important judgments. The regulations are binding on all the universities and colleges in India, and this regulation provides various measures to control the ragging in universities, in colleges and in schools. See the definition of ragging. Third Amendment in 2016, the latest definition of ragging. Ragging means any act of physical or mental abuse, including bullying and exclusion, targeted at another students, either it may be fresher or otherwise, on the ground of color, race, religion, caste, ethnicity, gender, including transgender, sexual orientation, appearance, nationality, regional origin, linguistic identity, place of birth, place of residence, or economic background. So, this is, we can say that the most important definition of ragging, which includes number of acts which amounts to a ragging. Under this 2009 regulation of UGC, some measures are provided under this regulation, such as number 1, the formation of anti-ragging committees and squads in colleges, universities, institutions, mandatory declarations and affidavits. The affidavits should be collected from the students at the time of admissions, from their parents also. No admission without these kind of affidavits. Then the next measure is about the awareness and publicity. The schools, colleges, universities should organize awareness programs in the campus about the anti-ragging laws. Then the next measure is supervision in hostels and campus. And last important thing is that in case of any ragging, prompt action and reporting is essential on the part of the institution, colleges or university. UGC regulations 2009 provides certain disciplinary action against the offender, such as suspension from the classes or hostel, debarred from the exams or scholarship, and another thing, expulsion from the institutions. So, these are the, we can say that the academic punishment provided under this regulation. And the most important thing is that the institution or the head of institution may file the criminal case against the offender. The head of the institution may lodge a first investigation report FIR against the offender if he commits this kind of act. So, apart from this UGC regulation 2009, another important legislation is that Maharashtra Prohibition of Ragging Act 1999. This act also provide the definition of ragging under section 2 subclause C. According to this section, ragging means display of disorderly conduct, doing of any act which cause or is likely to cause physical or psychological harm or raise apprehension or fear or shame or embarrassment to a student in any educational institution. So, this under this act also this definition is provided, educational institutions, and includes, means ragging includes number 1, teasing, abusing, threatening or playing a practical joke on or causing hurt to such student Or second thing, asking a student to do any act or perform something which is students will not in the ordinary course willing to do. So, this act will also amounts to ragging according to section 2 subclause C of this act. The next important thing under this act, the important aspect under this act, that is, under this act punishment also provided. Section 4 provides punishment for ragging, and this kind of punishment we can say that really hamper the educational career of that particular students. 2-year imprisonment and 10,000 rupees fine under section 4. And apart from this section 4, section 5 also provides certain academic penalties, such as the suspension of a student from the college, university or schools, then expulsion of a student, then the cancellation of admission of that particular student or offender, then the offence of ragging is cognizable, non-bailable and non-compoundable. It means the police may take the action against the offender. Apart from this Maharashtra Act 1999, the next important act legislation, that is Bhartiya Nyaya Sanhita. Under this Bhartiya Nyaya Sanhita, provisions are also provided, or we can say that the provisions are also applicable in relation to the ragging, specifically section 126, wrongful restraint. Under this section, 1 month imprisonment or fine up to 5,000 rupees or both are provided. Then section 127 of BNS, wrongful confinement. If any student doing any act which come under the definition of wrongful confinement, then he should be liable for 1 year imprisonment or fine up to 5,000 rupees or both. Under this BNS, the another important section, that is section 351 subclause 2, that is criminal intimidation. If any senior doing this kind of act which is come under the criminal intimidation, then that particular student should be liable for 2-year imprisonment or fine up to 5,000 rupees or both. Then the next important section, section 115 subclause 1, is also provides the punishment for ragging. Then section 74, that is assault or criminal force. Under this section also, imprisonment not less than 1 year, which may extend to 2 years, is also provided under this section. Then section 108, that is abandonment of suicide. If any act of ragging, cause suicide of any student which is come under the section 108, that is abandonment of suicide, and the punishment is up to imprisonment up to 10 years. It means if any act of ragging causes or it intimidate, or we can say that it encourage any student to do suicide or he commits a suicide, then it is a serious offence and that particular student is the offender is liable for the heavy punishment. So, at the end we can say that ragging is a punishable offence. It is a combination of legal, academic and institutional offence. Student and institution must work together for prevention of ragging in the campus. And at the end, I just want to mention one thing which is very essential, or we can say that it is very important, that is, say no to ragging and yes to respect and equality. Thank you.